case laws. We have with us Ms. Anagha and S. Rajendran sir for today's case law discussion. They will be discussing the case laws on related party transactions one by one. Like Anagha ma'am will be taking one case law and Rajendran sir will be taking up one case law. And then you can put up your questions in the chat box or one to one. Like, thank you everyone, and I welcome you both the speakers, and you can take up the session now. Thank you.
Thank you, Radhika. Good afternoon, Rajendran sir.
Thank you, Ms. Radhika, and thank you, Ms. Anagha. Thank you.
The methodology I thought we would follow is to maybe we have two cases to discuss. I'll be discussing the Phoenix ARC case, and Mr. Rajendran would be discussing another case. And I thought we would start with a little bit with the definition of the related party, just to get a background, and so that we are able to relate to the case what we are discussing. And then we will go through the facts of the case. So I'll be taking up the first case, and then I'll hand it over to Mr. Rajendran. And then maybe at the end we can take the questions, or after I finish the first discussing the first case, we can take the questions at that time also. So let's see how it goes. So let's start. Radhika, I should be able to share the screen, right?
Yes, ma'am.
Yeah, is this visible?
Yes, visible, Ms. Anagha.
Yeah, thank you, sir.
Thank you.
Okay, so this is a very brief note about the related party under IBC, and a short comparison between the definition of related party under the Act, under the IBC, and other acts. So where we use it in common parlance, which is the Companies Act and the AS 18. So this is where we all use this definition of the related parties. And even under the Insolvency Code also, we have this 5 subsection 24, which talks about the definition of a related party in relation to a corporate debtor, as well as the definition of a related party in relation to an individual. So both are relevant for our purposes, and we'll be discussing both of these definitions. So if anybody has any comments to add or anything in between, just feel free to interrupt, and we can take up your inputs and comments also. Great. So let's start. So who's a related party? Comparison between definitions of related party under various acts. So let's go with section 5, subsection 24, IBC of the IBC. A related party in relation to the corporate debtor means. So it includes a director or a partner of the corporate debtor, or a relative of a director or partner of the corporate debtor. So this we understand, the director or partner of the CD, or the relative of a director or partner of the CD. Then then the next is a KMP or a relative of the KMP of the corporate debtor. So anybody who falls, if the corporate debtor has the KMPs, then those KMPs will also be related parties, and the relatives of those KMPs will also be related parties. Then a LLP or a partnership firm in which a director, partner, manager of the CD or his relative is a partner. So any LLP or a partnership firm, so both are covered here, in which the director, partner or manager of the corporate debtor or any relative of the director, partner or the manager of the corporate debtor is a partner in such LLP or the partnership firm. Those will also get covered under the definition of related party. Then a private company, I'm going in the first column only, so under section 5, subsection 24. So a private company in which a director, partner or manager is a director and holds along with his relatives more than 2% of the share capital. So here we are covering the private limited company in which the director or the partner or manager is a director, and also holds, along with that, he should also be holding 2% or more of the share capital along with his relatives. Now here the private company in which the relative of is a director is excluded. So if you see the definition, a private company in which the director, partner or manager is a director. So here the relative is excluded. So it doesn't say a private company in which the relative of a director is a partner, or holds the shareholding. That is not covered here. Only the director, partner or manager in the who is will be a related party here. I mean, the private company will be a related party, and holding of the shares is mandatory. So if there is no shareholding, only by virtue of being a by virtue of being a director or partner there, it won't be that entity won't become a related party. So holding of the shares is mandatory. That 2% holding of shares is mandatory. Then a public company in which a director, partner, or manager of the corporate debtor is a director and holds along with his relatives more than 2% of the paid up share capital. Here again, the public company, the relative is of the director is excluded. And again, the holding of those 2% shares is mandatory. Then any body corporate whose board of directors, managing director or manager in the ordinary course of business acts on the advice, directions or instructions of the director, partner or manager of the corporate debtor. So this any other body corporate. So now it may be that over and above the private company or the public company, irrespective of the shareholding or anything here, any body corporate whose board of directors, managing director, manager in the ordinary course of business. So in the day-to-day parlance, whatever kind of activities this corporate debtor is doing, in that this body corporate should be acting on the advice, instructions or directions of the director, partner or manager of the corporate debtor. So that corporate debtor has that kind of an influence on this other body corporate in the manner that that board will be acting on the instructions of the director, partner or manager of this body corporate. So then that body corporate will also come under the definition of a related party. Any LLP or a partnership firm whose partners or employees in the ordinary course of business act on the advice, instructions, directions of the director, partner or manager of the CD. So in point number 6, we saw any body corporate. Here we are talking about any LLP or a partnership firm. So and whose partners or whose employees. So here in the case of a body corporate, it was whose board of directors, managing director or the manager acts on the instructions of the CD. Here it is the LLP or a partnership firm or their partners or their employees who act on the instructions of the director, manager or partner of the corporate debtor. So that will also such a LLP or partnership firm will also get covered. So irrespective of whether there's a commonality of the part of the partners or anything, these things will these LLPs will also get covered. Then the 8th one, any person on whose advice, directions or instructions a director, partner or manager of the corporate debtor is accustomed to act. So again, proving this practically about a person on whose advice, directions or instructions a director, manager or partner of the corporate debtor is accustomed to act, that will have to be shown based on the facts of the case, that that person is giving the instructions and the corporate debtor is used to act on those instructions. So, but such a person will become a related party of the corporate debtor. And this person here need not be an individual because it's under 524, so it could be any person. Then 9th is a body corporate, which is a holding subsidiary or an associate company of the corporate debtor. So the other company which is a holding subsidiary or the associate company of the CD or a subsidiary of the holding company to which the corporate debtor is also subsidiary. So a fellow subsidiary basically of the CD. So that will also become a related party. Then any person who controls more than 20% of the voting rights in the CD on account of ownership or a voting agreement. So holding 20%, but those not only 20% of shares, but 20% of the voting rights in those shares. That is important. So those 20% of the voting rights in the corporate debtor on account of the ownership. So maybe by way of holding of shares or under a voting agreement. So somebody having some disproportionate or some other kind of voting rights, that person will also get covered under this particular clause. Then 11th is any person in whom the corporate debtor controls more than 20% of the voting rights on account of the voting account of a voting agreement or the ownership. So any person in whom the corporate debtor is holding more than 20%. So of the voting rights. So only 20% of shareholding would in any case bring him under the definition of the associate company. But any person in whom the corporate debtor holds more than 20% of the voting rights also becomes a related party. So such a person will also get covered in the definition of the related party. Any person who can control the composition of the board of directors or corresponding governing body of the corporate debtor. So such a person also will be a related party. So somebody who can control the composition of the board of directors, somebody who may say by way of an agreement or something, has the power to control the composition of the board or to appoint the majority of the board of directors to remove or replace the board. Such a person who will be said to have control on the composition of the board, and he'll also become a related party. Then any person who is associated with the corporate debtor on account of participation in policy making process of the corporate debtor. Now look at this 13 point number 13. It's very vague and it is very wide. So, a lot of things can come under this particular definition. We just have to go and extend, when we are doing that this check of whether somebody is a related party or not. All these things are going to be really relevant. And this is how the various courts also have upheld that while deciding whether somebody is a related party or not, take into account or give a as wide an interpretation as possible, so that we are able to go to the root of the issue, whether somebody is a related party or whether or somebody is trying to disguise himself as a non-related party when actually he is a related party in that sense. So point number 13 is any person who is associated with the corporate debtor on account of participation in policy making processes of the corporate debtor, having more than 2 directors in common between the corporate debtor and such person. So if we saw previously that the private company or the public company where the shareholding of 2% was important or was relevant to become a related party. Under this clause, having more than 2 directors is common and sufficient. It doesn't talk about the shareholding. So not holding even a single share or by the director will also make it a related party if there are more than 2 directors who are common. Then interchange of managerial personnel between the corporate debtor and such person. So typically in cases where maybe the same offices are being shared, and typically the support staff, the accounts, the HR, and those staff is common. They work for both the companies. That is where you can call them as a related party. So interchange of managerial personnel between the corporate debtor and such a person. Provision of essential technical information to or from the corporate debtor. So any person who is associated with the corporate debtor on account of providing the essential technical information, either to the corporate debtor or he is getting such information from the corporate debtor. So even somebody with whom you have a technical know-how agreement, something like that. So that person may not actually have a seat on the board, but such a person will be can be called as a related party if we are able to show that he forms part of this provision of essential technical information to or from the corporate debtor. So this was the definition of under 524 with regard to the related party of a corporate debtor. Now let us look at the definition of a related party with reference to an individual under the IBC. So some part of it is similar to the definition under the Companies Act. Even under 524 it was also a bit similar to the definitions under the Companies Act. So here for an individual, so a related party in relation to an individual means a person who is a relative of the individual or the relative of the spouse of the individual. So anybody who is related to that person, spouse of that person or spouse of that particular relative, they will be covered under the definition of related party. Then a partner of a LLP or a LLP or a partnership firm in which the individual is a partner. So here the relative is not covered, here only the partner is covered. So like we saw there, only the director was covered, the relative was not covered. So similarly here only the partner of the LLP is covered or the LLP or the partnership firm, and the relative of such a partner is not covered here. Then a private company in which the individual is a director. So we are talking about whether the individual is a related party or not. So a private company in which the individual is a director and holds along with the relatives more than 2% of the share capital. So again, that individual whom we are talking about, that he is a director in that private company and holds more than 2% of the capital along with the relatives. So here the private company in which the relative is again excluded and holding of the 2% of the shares is mandatory. So something similar to what we had in case of under 5 subsection 24. Same is the case with a public company. So private company and public company, wherever that holding of the 2 shares by that particular individual along with the relatives is mandatory. Then a body corporate whose board of directors, managing director or manager in the ordinary course of business acts on the advice, instructions or directions of that individual. So that body corporate with reference to this particular individual, that body corporate will become a related party for the corporate debtor. A LLP or a partnership firm whose partners or employees in the ordinary course of business act on the advice, directions or instructions of this individual. So something similar to what we saw in case of 524. So that LLP or partnership firm whose partners or employees are used to acting in the ordinary course of business on the instructions of this particular individual. So that individual will become the related party. A person on whose advice, directions or instructions the individual is accustomed to act. So some other person who advises or directs or instructs this particular individual, and this individual is accustomed to act on the basis of the instructions of that such a person. So he will become a related party. Company where the individual or the individual along with its related party own more than 50% of the share capital of the company. So here the shareholding limit is 50%. Or controls the appointment of the board of directors of the company. So here we saw the control on the appointments or control on the composition of the board. That was by way of the voting rights or through a voting, some ownership agreement or by the voting agreement. In this case, it is a company where the individual or the individual along with the related party own more than 50% of the share capital of the company or control the appointment of the board. So this was with relation to an individual. Then this is a new clause which is not covered under 524. So a person who is a trustee of a trust in which the beneficiary of the trust includes the individual, or the terms of the trust confers a power on the trustee which may be exercised for the benefit of the individual. So such an individual will become a related party for the corporate debtor. Now, just as if you look at a quick comparison with the definition under the Companies Act. So wherever there's a difference, so see the director or his relative is already covered under the Companies Act. The KMP is covered. The firm in which the director, manager or relative is a partner, that is already covered. The relative is covered there, which is not the case in the 524. Then a private company in which the director or manager or his relative is a member or director. So even holding one share triggers this clause. Here that percentage is 2%. Here only holding even a one single share will also trigger this clause of related party. For in case of public company, again the definition, again the reference is for holding of shares and where the shareholding should be minimum 2%. So here again the public company in this definition the relative is excluded and holding the shares is mandatory. Under the Companies Act, again, any body corporate whose board of directors, managing director or manager is accustomed to act in accordance with the advice, instructions or directions of the director or manager. So this clause is similar. And nothing shall apply to the advice, directions or instructions given only in a professional capacity. So there's an exception here that the instructions given in the professional capacity are excluded from, I mean, those persons are excluded. Those instructions are said to be given only in the professional capacity. Then any person on whose advice, directions or instructions a director or manager is accustomed to act. Again, any instructions given in the professional capacity are excluded here. This is again common body corporate, which is a holding company, subsidiary company, an investing company or a venturer of a company. All those things will be included in the definition of this related party under the Companies Act. Then there's a residuary clause under the Companies Act, such other person as may be prescribed. So which talks about a director other than an independent director or KMP of the holding company or his relative with reference to a company. So any director who is other than an independent director or the KMP of the holding company or his relative vis-a-vis that company. So such a person will also be included in the definition of the related party. Now under AS 18, it only talks about it doesn't categorize the persons as such. It only talks about the people who have significant parties who have significant influence. And if you look at the definition here, so parties are considered to be related if at any time during the reporting period, one party has the ability to control the other party or exercise significant influence over the other party in making financial and or operating decisions. So it doesn't categorize by shareholding or by agreement or anything. It just talks about whether that other party has the ability to control this party or exercise significant influence over the other party in making the financial and operating decisions which are there in the day-to-day working of the company. So such any party, it may be an individual, it may be a body corporate, LLP firm, everybody will be covered in this. So the AS 18 definition is pretty simple in that sense. So proving the significant influence and control is of course the job of the professionals there. So let us look at the definition of the relative. So everywhere we have seen the definition. We have seen that either the related party or a director, KMP, or anybody, and a relative. So definition of relative is relevant everywhere. So under IBC, it is given in explanation to section 524A. So who is the relative in case of the IBC, and a comparison of that with the Companies Act. Okay, so members of HUF are common in both the cases. So if you see, the first column is the definition under IBC, and the right side is the definition under the Companies Act. So members of HUF are common in both the definitions. Husband and wife, they're common. Father, now under the Companies Act, making it a bit wider, it says father including stepfather. Here it says mother including stepmother, son including stepson, which are not covered in the IBC definition. So not specifically saying including stepfather and all those things. Then son's wife, son's daughter and son. So these are not covered under the Companies Act. So from here on, the definition under IBC starts getting a lot wider. Then the daughter, daughter's husband, daughter's daughter and son, brother. So again, the stepbrother is not defined, like not included here in the definition. Brother's wife, brother's daughter and son, sister, sister's husband, sister's son and daughter, grandson's daughter and son, grandson's daughter and son, father's father, father's mother, mother's father, mother's mother. So all these things who are like, the kind of the extended relations also, all of those are covered in the definition. So mother's mother, father's brother, father's sister, mother's brother, mother's sister, all of these will get covered in the definition of IBC. So maybe when we are handling cases and trying to find out who is a related party, having this chart and writing each person's name against it, so that if we are examining the transactions which are entered into by the CD, we are able to identify whether any transactions are entered into with any of these entities. And then if that transaction is there, then it will become a related party transaction, and then whatever has to follow about the inclusion on the COC or the 29A applicability, or whether they're eligible to file a resolution plan, all those things will come into picture based on that. Now just a quick look at the definition of control and significant influence, since we are talking about AS 18 also. So these two are not defined under the IBC, but under the Companies Act, control is defined, and under AS 18, control and significant influence, although both those things are covered. So under the Companies Act, control shall include the right to appoint majority of the directors, or to control the management or policy decisions exercisable by a person or persons, which may be acting individually or in concert, directly or indirectly, including by virtue of their shareholding or management rights, or shareholders agreements or voting rights, or in any other manner. So this is a pretty wide definition, and it means control of at least 20% of the total voting power, or control of or participation in business decisions under an agreement. So this is a significant influence. Under AS 18, control means ownership directly or indirectly of more than 1/2 of the voting power of an enterprise. So to drill it down further, 50% or more of the voting power, or control of the composition of the board of directors in the case of a company, or of the composition of the corresponding governing body in case of any other enterprise. So you can see similar wordings which are used in the IBC also. A substantial interest in voting power and the power to direct by statute or agreement the financial and or operating policies of the enterprise. So somebody who may not be falling under these other categories by virtue of any agreement or something, he may be able to direct the financial and operating policies, and such a person will also be said to have control. And a person who has participation in the financial and or operating policy decisions of any enterprises, but not control of those policies. So somebody who's not able to exercise control in that sense, but who is able to participate in the financial and or operating policy decisions. So such a person will be said to have a significant influence, exercising significant influence. So this is, I just wanted to cover this brief definition of the related parties, so that we have a background about what we are going to discuss here. So now let's start with the Phoenix ARC case. I have prepared a note and which I'll be circulating after the session, so I can request Radhika to circulate it. So just a brief note on the this case. It has gone through various stages. So let us start with the stage of the NCLT NCLT. From there, it went to the NCLAT, and from there, it went to the Honorable Supreme Court. And then finally, the Supreme Court decision, which is now binding on all the parties and all of us rather. So this case started in 2018. We are so used to calling this as the Phoenix ARC case that we don't even know the name of the corporate debtor. So, when I was trying to study for this, that is when I came to know that the name of the corporate debtor is AKME Projects Limited. So we just know it as the Phoenix ARC case. So this was a petition filed before the New Delhi bench of the NCLT, and it was filed by an operational creditor, one Mr. Hari Kishan Sharma, who was an ex-employee of this company, and for a salary debt of 12 lakh rupees. So that Acme Projects had not paid his salary of around 12.26 lakhs. And this petition was filed under Section 9, and this was admitted sometime in the month of April or April 2018. And the IRP was appointed. IRP constituted the COC. And while constituting the COC, there were two claims which were received. So one was received from Spade Financial Services, and another claim was received from AAA Landmark Private Limited. So both these entities filed their claims saying that we are financial creditors. Now, the IRP, based on his own wisdom, he said that both of these do not fall under the definition of the financial debt, and he did not admit their claims. So he had rejected both their claims and refused to admit them as financial creditors or include them as a part of the COC. Now, both these parties filed applications before the NCLT saying that their claim was rejected by the IRP and asking him to consider the claims. So on 31st May 2018, NCLT Delhi passed an order directing the RP to consider their claims and include them in the COC based on the merits of their, on the basis of the claims which were filed by them. So there it did not go into the details of, the reasons and all those things. So there was a direction to the RP by that order to include both of these in the COC. Now, as directed, the IRP included them in the COC, and the COC meeting was also held after that. Now, apart from these two entities, there was Phoenix ARC. So the Phoenix ARC had taken over the loan from some other from Karnataka Bank, and Phoenix ARC was a part of the COC, and Yes Bank was also a part of the COC. So both these financial creditors took objection to the inclusion of the Spade as well as the AAA Landmark on the COC, because by virtue of inclusion of these two entities, their shareholding, their voting power in the COC, which was 15.27%, from that it got reduced to 4.28% in the COC. That is, a voting share was reduced from 15.27 to 4.28%. So both of them filed their objections and said that they were objecting to the inclusion of these of Spade and AAA in the COC. So for this, the Yes Bank filed two applications, 267 and 268, and Phoenix ARC filed two applications, 337 and 338 of 2018 before the NCLT. And a lot of hearings were, they took place. This were filed sometime in the month of June 2018, and they were finally decided in July 2019. So, the whole 1 year till the time. Till this time of 1 year, the COC could not function because the constitution itself was not decided. Without the decision, without the formation of the COC, the CIRP could not have commenced or could not have progressed in that sense. So the RP has also filed a number of applications. So IRP had to continue, then the IRP got changed. So lot many things happened in this period of 1 year. And so, but we are not concerned with that for the purposes of our discussion today. But these two applications, when they were finally decided in July 2019, the detailed order was received from the NCLT Delhi bench. Now, some brief facts which they have discussed in the case is that the corporate debtor was incorporated in December 2003. The original subscribers of the corporate debtor were one Mr. Arun Anand. So he is the key person here. So that the whole case of this Phoenix ARC revolves around this person, Arun Anand, and his relationship with various other entities, his various roles that he has played in a number of other companies, and how then they came out to be the related parties. So how the NCLT also held that these are related parties, even though they did not fall under 524 as on the date of CRP. No, so we have to understand the difference that the courts have gone beyond the CRP date, and even though these parties did not fall under the definition as on the date of the CRP, the courts went back in time and upheld that this is that these parties are indeed related parties, and then the reasons for that, and because of which they should not be forming part of the COC. So main contention, like was raised by Phoenix ARC, was whether these people are entitled to be included in the COC. So this original subscriber is this one Mr. Arun Anand, and there were a few others. So there was his son also, and there were 5 other persons who formed this company, Acme Projects Limited, which was in the business of project development and construction and those things. Later on, this his share, that is Arun Anand's share, was taken over by Joint Investments Private Limited, a company which was acting through Anil Anand, who was another director of the corporate debtor. And this Joint Investments Private Limited is a GIPL. It purchased the shares from Arun Anand and became the majority shareholder. So at the beginning, there were the 7 subscribers. Sometime in between, these shares were purchased by GIPL and it became the majority shareholder. Now, GIPL presently, like when the CRP started or when these applications were filed, the CD had only 2 shareholders. One was GIPL, which was holding 80% shares, and one foreigner, Helmut Nance, who was holding 20%. So only 2 shareholders were there in the corporate data. Now the constitution of GIPL, Anil Nanda, so who was another business person who held 65% in GIPL. Then one other Hariraj Investment, which held 20%, 24%, and AN Enterprises held 9 or around 10%. So this Anil Nanda and Arun Anand, the relationship between these 2 persons is crucial for understanding this entire, what all happened in this particular case. So we need to look at the first the connection between Arun Anand and the CD. Like we saw, he was the promoter of the CD. So he incorporated this company. He sold his shareholding to GIPL. Now, later on, when his shareholding was sold and GIPL became the majority shareholder of the corporate debtor, and now GIPL is the majority shareholder of GIPL is Anil Nanda. So again, Anil Nanda and this Arun Anand, these 2 entities are these 2 persons are related to each other. How Arun Anand held various executive positions in the companies where Anil Nanda held managerial positions. So Arun Anand was holding executive positions where Anil Nanda was holding managerial positions, or there were other companies which were formed or promoted by Anil Nanda. So this group was known as the Anil Nanda group of companies, in short TANG, T-A-N-G. So in the TANG group of, in the TANG companies which were promoted by Anil Nanda, Arun Anand held various positions over the period of time. So the chart has also been given in the in these cases. So right from 1979 till 2013, Arun Anand held a number of positions in the Anil Nanda group companies, right from starting as a co-employee or as a colleague to becoming the group CEO of the Anil Nanda group of companies. So over a period of time, they had a lot of relationships inter se, holding different positions in different companies, and maybe as executive director, vice chairman, managing director in the group companies, all of those. And eventually till 2013, he was a group CEO. Now Arun Anand, so now we look at the relationship between SPADE, that is these 2 entities who had filed the claim. So one was SPADE and one was AAA. So connection between them and the corporate debtor. Okay, so this SPADE was incorporated sometime in the year 1994. So it was a very old company. The promoter was Arun Anand. So the Arun Anand, which is like who is at the center of this entire this transactions. So it was promoted by Arun Anand. He was holding around 59% shares by himself of Class A shares, and the other shareholders were his group companies, were his relatives and GIL. So GIL, that is the joint investment, that was holding 5%. And the other shares, the balance 95% shares were held by Arun Anand and his family members. So the immediate family members, his wife and son. And the Class B shares in that particular company were held 100% by Arun Anand. So it was completely owned by that entity was completely owned by Arun Anand. And this other entity, AAA Landmark Private Limited, it was a wholly owned subsidiary of Spade. So if you look at it, Arun Anand is there in the AKM projects, that is the corporate debtor. He has floated this company, which is Spade, which is 100% held by him. And again, AAA Landmark, which is a 100% subsidiary of Spade. So this is the inter-se relationship between these three entities. Now, if we look at the transactions between the corporate debtor and these other two entities, so these transactions have happened sometime in the year 2009 onwards until 2013. So Spade has given an intercorporate deposit to the corporate debtor of 66 crore rupees. So Spade as we have seen, Spade is 100% owned by Arun Anand, and he has this company has given an intercorporate deposit of 66 crores to the corporate debtor. The rate of interest as per the MOU or as per the agreement was of 24%, but in the claim, the amount of the interest rate was claimed was only of 12%. Now this ICD, this intercorporate deposit, was secured, as per the MOU. This was secured by 37 flats in various other projects of the corporate debtor, but the charge was not registered. On paper, it was a secured charge, but the charge was the secured loan, but the charge was not registered with the ROC. Now, out of this 66 crores, 43 crores was given to Arun Anand. No, by way of even though the agreement talked about Spade giving that 66 crores to the corporate debtor, out of those 66 crores, 43 crores were given to Arun Nanda for his own disposal. And this is by way of the understanding between the parties. Spade was also hired during the period 2009 to 2011. Spade was hired as a consultant by the corporate debtor for advising in its various projects. So these are the relationships which the corporate debtor had with Spade. Now let us look at the relationships which the corporate debtor had with AAA Landmark. So AAA Landmark and the corporate debtor executed a number of agreements right from the year 2009 till 2013. A number of agreements were entered into by the corporate debtor with AAA Landmarks, and all of these agreements. So if we look at, this was a plot buyer's agreement of 2009. Then there are other MOUs of 2011, development agreements of 2012. And then there is an agreement to sell of 2012, again concerning various projects of the corporate debtor, which it was undertaking at different locations. Now, in terms of the development agreement of March 2012, which was entered into by CD, that is the corporate debtor, with AAA, 38.3% of the development rights of one project. So there was one project which was known as Acme Raga. So 38.3% of the development rights of that project were sold by the CD to AAA for some 33 crore rupees. So this Acme Raga again is at the center of the controversy here. So again, which went on to show that this is a related party and how all these transactions are interrelated. Now, again in 2012, when agreement to sell was executed, superseding this development agreement. So this development agreement was of March 2012. Where the 38.3% of the development rights in that Raga project was sold by the corporate debtor to AAA. Now in 2012 October, another agreement to sell was entered into, and which was overriding the previous development agreement, and the value enhanced from 32 crores to 43 crores. So there's the difference was that there was an enhancement, and the CD was selling their own flats outside at a much lower rate, but for this particular agreement, this value was enhanced from 32 crores to 43 crores. So here the applicants have alleged that in the agreement to sell, the price was taken at a higher rate than the other transactions which were done before and after this the date of this agreement, and this itself shows that the agreement was not at a fair price or at an arm's length, and these parties are related parties. So that was one more contention of the applicants. Now we have seen the relationship between Arun Anand and the Tang, that is the other group of companies. Now joint investment, which is again now the majority holding of Acme, the majority shareholder of Acme. This JIL holds about 2%, 1.5% in Spade. No, the SPADE is a financial services. It was a form for financial services. So this 1.45% of shares of the of SPADE are being held by this Joint Investment Private Limited. So again, there is an inter se relationship between these two entities. And we know that SPADE belongs 100% to Arun Anand. So again, all these three entities were related to each other. SPADE is holding 24.5%. SPADE was holding 24.5% shares of the corporate debtor, and it was sold to JIPL in April 2007. So even though as on the date of CIRP there was no inter se shareholding between them, so they could not fall under the definition of 524. But in 2007, that 24%, 24.5% shares which were held by SPADE in the corporate debtor was sold to JIPL. So again, there was this history of interconnected of inter se shareholding. Arun Anand ceased to be a director of the corporate debtor in 2007. So around that time, when the shares were also sold, he also resigned from the directorship of the corporate debtor. So Arun Anand he resigned from the corporate debtor. But he continued to be director in the other Anil Anand group companies, that time group of companies. He continued to hold various positions as we have discussed till 2013. Then Arun Anand and his son's shareholding in Acme Projects of 20,000 equity shares, and around 30,000 equity shares they both were holding, the father and son. This was sold in the year 2004-2005 to again the joint investment, making joint investment the majority shareholder of 80%. Now, the applicants, that is the Phoenix ARC and Yes Bank, the arguments which they have put forth to show that these two are related parties are pretty in detail, and they're saying you need to go beyond the definition as on the CRP date. You need to go and look at the actions which have taken place or the transactions which have taken place in between these parties. So what they're saying is that Arun Anand, who is the promoter, director and shareholder of AAA Landmark, and SPADE. So we have seen that SPADE is 100% owned by Arun Anand, and AAA is a subsidiary of SPADE. So Arun Anand is indirectly or directly the promoter, director and shareholder of both these entities. He was appointed as the group CEO of the Anil Nanda group in 2012. He was also one of the promoters and directors of the corporate debtor, and the company is also a part of the Anil Nanda group. So this company became a part of the Anil Nanda group when he acquired the shares through GIPL. This appointment has been admitted by Arun Anand in the affidavits which he has filed or in the replies which he has filed before the NCLT. So he has admitted to these facts in saying that wherever he was appointed, the date of appointment and those things have been given by him. Now, prior to the appointment as group CEO, he was appointed as consultant to the corporate debtor. So he has resigned in 2007. After that, he was again appointed as the consultant to the corporate debtor in 2011. He was also appointed as the strategic advisor to the corporate debtor in 2011. So, and his employment was further continued with the corporate debtor from 2012 onwards. So even though he may have resigned from directorship in 2007, he may have sold his shares in the year 2004-5. But by way of all these relationships or by way of all these engagements, so maybe as a consultant or a strategic advisor or in any other capacity, he continued to be associated with the corporate debtor even thereafter. So only just by virtue of resigning from directorship or giving up his shareholding, his relationship did not end there. Again, it is important to note that SPADE was rendering consultancy services to the corporate debtor from 2009 onwards. So SPADE was in this business of giving consultancy since 2009 to the corporate debtor, and at the same time SPADE, he was owning SPADE and he was acting in these different capacities in the corporate debtor. On account of the fact that Arun Anand was the group CEO of Anil Nanda Group, he would fall within the ambit of 524B of the corporate of the related party definition, being a key managerial personnel. So he may not have been on the board or anything, but he becomes a KMP. That is the contention of the two applicants, that is Phoenix ARC and Yes Bank. Even otherwise, Arun Anand and SPADE, on account of being the CEO, strategic advisor or consultant at the relevant time, would also fall within the definition of related party in terms of 524H and 524M and I. This is the contention which was put forth by the applicants. Further, they have again elaborated which all positions he was holding in the Anil Nanda group, so which establishes a close nexus between the three entities, that is the corporate debtor, SPADE and AAA Landmark. he is also closely, Arun Anand is also closely related to one of the directors of the corporate debtor, Mr. Sonal Anand. So Sonal Anand was the wife of Arun Anand. So Arun Anand's wife is the sister of Sonal Anand, and Sonal Anand was the director on the board of the corporate debtor. So because of this, also they are saying that there's a very close relationship between Arun Anand and Sonal Anand by virtue of this personal relationship also. And Sonal Anand was a director of the corporate debtor till November 2013. So even though Arun Anand may have resigned, so Sonal Anand continued to be a director for all this time, and he was a related party. Now Sonal Anand and Anil Nanda are still directors in Acme Westover project. So this was another group company where they continue to be the directors. So even though Arun Anand may not directly have been on the board there, but Sonal Anand was there and Anil Nanda are still directors over there. The said Sonal Anand and Anil Nanda have been common directors on the board of a number of other companies. So they have given a list of companies where Sonal Anand and Anil Nanda have been common directors, and all those companies are still into existence and they're still carrying on business. So this assumes significance in the fact that Sonal Anand was the director of the corporate debtor at the relevant time when the transaction between the corporate debtor and AAA Landmark and the transaction between the corporate debtor and Spade took place. So whatever loans were allegedly given by these two entities to the corporate debtor, at that relevant time, Sonal Anand was a director of the corporate debtor, and of course he was also on the board of these other companies, even though Arun Anand may not have been a common director. So accordingly, their contention is that he falls into the definition of the relative, what we saw under 524A of the IBC. They also pointed out that Arun Anand in his affidavit has admitted that about all these relationships. He has admitted about the directorships held by Mr. Sonal Anand and the other directorships held by he himself and the other appointments which he himself held over the period of time. So accordingly, all these things have been admitted in the affidavit. Now, the IRP, when he was rejecting the claim in May 2018, has noted that Spade Financial Services was claiming monies transferred by it, that is transferred by Spade to the account of AAA Landmark and not to the account of the corporate debtor. So like we have seen, out of the 66 crores, as per their understanding, 43 crores was to be given to Arun Anand. So that it was given to AAA Landmark, it was not given to the corporate debtor. So the IRP had correctly identified that this amount never came to the corporate debtor. This amount was given to AAA Landmark, and hence there is no question of Spade now claiming that money from the corporate debtor. So this was something which was in the rejection letter, the IRP had included that, and this was used by the applicants, of course, to say that these monies have never been given to the corporate debtor, and no interest was also claimed on such debt. So there was even in as per the books, this interest was not claimed. This clearly establishes a nexus between the corporate debtor, the AAA Landmark, and Spade Financial Services. So again, these three entities in that sense are related, and those will be that nexus was again established here. And then they went on to say that for all these reasons, Spade and AAA Landmark cannot be considered as financial creditors and ought not to be allowed to participate, represent, and vote in the meetings. Now, it is also submitted that AAA and Spade are related parties, which has been this fact was concealed from the IRP as well as from the NCLT when this application was made in 2018, in May 2018, when that application was made. When the NCLT directed the IRP to include them on the COC, these facts were not disclosed to the tribunal or to the IRP. So because of which those two were included in the COC. And again, there are AAA has a number of other litigations. So AAA and Spade together has this number of other suits which have been filed for recovery. So based on those suits also, the summary of those was given. And from that also it was found out that those two are acting together with each other, and they are nothing but the one and the same company. And Arun Anand being a very close, having such a close nexus with these two entities, they would also fall under the definition of the related parties. Now, after all these contentions, the rebuttal which was given by these by Spade and AAA. No, so they have relied upon the fact that he may have acted, that Arun Anand may have acted in so many other companies. He was a chartered accountant and he was a professional CEO in many, in different companies. And he has extensive experience in financial and real estate matters. And that was the reason why he was appointed in the Nanda group of companies also. And he incorporated Spade Financial Services in 1994 since he had expertise in financial matters. Acme was incorporated thereafter, so there is no question of there being any nexus as such, and Acme being in a completely different field, and which was incorporated with friends and family members in the year 2004. And the shares, Arun Anand sold his own shares to JIPL later on, so he has completely exited from the corporate debtor after his resignation also. So he sold his shares in 2004-5 and he resigned from directorship in 2007, and thereafter he has no connection whatsoever with the corporate debtor. So this was the contention which was taken by Spade and AAA. Again, they have he's not also a promoter as per section 16 of the Companies Act. So all these things were discussed, that this is the only thing which they have related, that he has never attended any board meetings or he has never attended any shareholders meetings after 2007 of the corporate debtor. He has never tried to exert any control or any influence in the financial or business decisions of the corporate debtor, because he was never holding such an authoritative position, or he did not have such administrative authority, nor was he a signatory to any contract, nor was he a signatory to the bank accounts. So all those things they have taken as a defense to show that he was in no way connected with the corporate debtor once he resigned from the directorship and once he sold his shares. Then again, the other thing which they have said, that both AAA and Spade have never held any shares of the CD. There is no cross holding as such, and there was no shareholding, there was no common directorships in after 2007, and with any of the other Anil Nanda group of companies also. So they have tried to segregate that Anil Nanda group of companies has nothing to do with the corporate debtor, and only Arun Nanda, by virtue of he having resigned and not holding any position in the corporate debtor, he was not a related party. The only Sonar Anand was only a non-executive director, so he did not have any, he was not drawing any remuneration from there, or he did not hold shares in the corporate debtor. He was just a relative, and since Arun Anand was not there on the board, there was no question of him being a related party. Then again, the other thing which they said was that the audited balance sheets of the corporate debtor reflect the intercorporate deposit which was taken from Spade, or whatever transactions were entered into with AAA. All those transactions, the suits and litigations, everything has been disclosed in the audited balance sheet, and nowhere there is any nexus as such, which has been given by them in the affidavit also. And whatever shares have been invested, so how did Anil Nanda invested such and such amount in the for purchasing the shares in the corporate debt and all that? So they have shown that, saying that this is nothing, there was no nexus, this was purely a commercial transaction. So the list of litigations is given, and all those things have been brought on record in the reply before the NCLT. And similar replies were also filed. So in all there were 4 applications in all. So similar replies were filed in all these 4 applications. And to say that by no stretch of imagination can these be called as related parties, because there is no commonality of directorship, there's no common shareholding, and this Nanda group of companies is something which is totally different and which has nothing to do with the corporate debtor. And AAA and Spade were at one point of time, maybe had a common director in the form of Arun Anand. But since his resignation in 2007, there is no question of there being any common nexus or any being categorized under the definition of a related party. So all these things, in all these 4 applications, similar kind of replies were filed by these two related parties. And the prayer was that we don't fall under 5, we are financial creditors, we have given financial debt to the corporate debtor. There's a MOU, the supporting MOU, which is made to that effect. The interest rate was decided, everything is there in the books of the corporate debtor. So we are not related parties, and we are financial creditors, and we should be included in the in the COC. So the question which was there before the NCLT was what is the nature of the transaction between the parties, and does it qualify to be treated as a financial debt as defined under section 5 subsection 8? and what is the date on which there should be relation between the two parties for the alleged financial creditor to be included in the definition of a related party. So both these things are relevant. It's not only about whether it is to be called as a related party or not. Again, what is the relevant date when that relation should be checked? So both these questions have been dealt with by the NCLT in this July 2019 order. So they have gone on to define what is a financial creditor, what is a financial debt, and after that, they're saying that perusal of the documents pertaining to the intercorporate deposit stated to have been given by SPADE to the corporate debtor. So from 2009 to 2013 shows different points. So they have brought out what all points are there, and on the basis of which points they have said that based on the above facts, the transactions pertaining to giving of intercorporate deposits by SPADE to CD appears to be collusive, as the MOU for the same has been signed more than 2 years after the beginning of the transaction, and the rate of interest actually stated to be charged is half of the interest mentioned in the MOU, as also a major portion of the ICD was credited to the account of Arun Anand, director of SPADE. Thus, it is seen that the entire amount was not disbursed to the CD, as well as there is variation in the consideration for the time value of money as per the MOU and the claim filed before the IRP. Accordingly, this transaction does not qualify as a financial debt as defined under section 5 subsection 8, and SPADE Financial Services does not qualify as a financial creditor. So outright they have said that SPADE is not a financial creditor at all. So there's no question again beyond that of the related party or its inclusion in the COC. Now, as regards AAA, they have said that it is seen that as regards to the same property, the parties entered into several agreements over a period of 3 years. By the development agreement of March 2012, 38% of the development rights of that Raga project were sold to AAA for 32 crores. And subsequently in October 2012, the agreement to sell superseding this development agreement enhanced the value to 43 crores. So what we discussed. The multiplicity of agreements regarding the same property with no explanation or rational reasoning regarding variation in rules and of transaction shows that these transactions are also collusive in nature, and an attempt to divert the properties of the corporate debtor to AAA for reasons best known to the parties. It is also noted that the transactions between the CD and AAA as well as SPADE were done during the period when Arun Anand, who along with his family members is the promoter and director of SPADE and AAA Landmark, was associated in various capacities from 82 to 2013 with the corporate debtor and its directors and the group of companies to which the CD belongs. It is during this period only that Arun Anand promoted and subscribed the Memorandum of Association of the CD, SPADE and AAA Landmark. He and his family members at various points of time also held shareholding in the group companies of the Anil Nanda Group. It is also seen that the alleged financial transactions of SPADE and AAA Landmark with the CD occurred during the period of 2009 to 2013, the time when he was the consultant to the CD. So through SPADE was appointed as the consultant and the strategic advisor in his individual capacity to the CD, and finally Group CEO of the Anil Nanda Group. Considering the above facts, we are of the opinion that the transactions between the CD and SPADE and AAA are collusive in nature and do not qualify as financial debt. So NCLT here has held that both these parties do not fall under the, the amounts which are given by these parties do not fall under the definition of the financial debt, and accordingly they do not qualify to become the financial creditors. And then from there on they go on to say that these persons, because they don't qualify as financial creditors in the first place, and now again it is discussed whether these are related parties. So now they have discussed the definition of the related parties of 524 and 524A, and after that they say as a conclusion, there is no doubt in our mind that Arun Anand and his companies, namely SPADE and AAA Landmark, were related parties to the corporate debtor. However, after 2013, Arun Anand resigned from all the companies of the Anil Nanda Group, and so they are no longer related to the CD at the time of filing of application of CIRP. Before parting with this application, we would like to observe that the affairs of the CD as well as the group of the Arun Anand companies are deeply entangled, and it is difficult for the tribunal in a summary jurisdiction to unravel the same. Considering that the CD and SPADE and AAA were in close business relationship in the past, and also the fact that the accounts of the CD have not been finalized and audited since 2016, we have no hesitation in allowing the instant applications filed by Yes Bank and Phoenix ARC. So they allowed all these 4 applications by way of this agreement. Now, against this order of July 2019, both AAA and Spade, they went in appeal before the NCLAT. NCLAT upheld the decision of the NCLT. From there, they went again to the Supreme Court. And in the Supreme Court also, this decision was upheld there. And in the Supreme Court, this it has been elaborated as to why no further whatever we discussed in the definition of accustomed to act and having that close nexus and all those things have been described in detail, while upholding that they are not related party. While I mean they are not financial creditors, but they are related parties of the corporate debtor. So all those things they have given the various, they have discussed about the various agreements, the various MOUs which were entered into by the corporate debtor with Spade, then with AAA. All these things have been discussed in detail. And finally, it has been held that even though they may not have been the related parties as on the date of filing of application of the CRP, but looking into the transactions beyond what was there on that particular date, then these two are related parties, and we need to go beyond merely the relationship as on the date of the CRP. So this was held in this also. Phoenix had one contention when it went into Supreme Court. The Phoenix went into Supreme Court because the NCLAT had held that these are financial creditors, but they are related parties, so they would not form part of the COC. So against which Phoenix ARC went to Supreme Court, challenging the decision of the NCLT to hold them as the financial creditors. So again, in the NCLT, these were not held as financial creditors, but they were held as related parties, and hence debarred from the entire process. So this is in short the summary of the Phoenix ARC judgment. It's 5 o'clock. I think let Mr. Rajendran discuss his case, and then we will discuss all the aspects at the end.
Thank you very much, Ms. Anagha.
Yes.
Thank you. It was quite interesting to get a good idea about the related parties under IBC as well as Companies Act, as well as AS 18. I think that was a good kind of an exposure for people like us in the profession, in the insolvency profession. Thank you very much. And the case also, the Phoenix ARC case has been widely reported, where the related parties have been clearly identified and said that collusive agreement. So thanks a lot, Ms. Anagha. Very good evening, ladies and gentlemen. I am Rajendran, insolvency professional from Chennai. I am a cost accountant as well as company secretary. I also had some experience of working in a bank during early days of my career. And I see, quite a lot of distinguished audience spectators here, including the past chairperson of IBBA, Mr. M.S. Sahu. Thank you very much, sir, for being present. And thanks a lot, ladies and gentlemen. Before I start my, brief presentation, I would like to make it very, very brief so that you would like to have a little more time for, shooting your questions on both the case laws. I have a similarity with Ms. Anagha. Ms. Anagha is the company secretary. I'm also a practicing company secretary. So not on that platform. The similarity is on another platform. She handled a case, of Phoenix ARC. In my case also, the case law which has been given to me, there is also another Phoenix. So there is a kind of a strange coincidence. Let me just take you through a brief, on my understanding about this particular case. This case is called Telangana State Trade Promotion Corporation versus AP Gems and Jewelry Park Private Limited. Can I share take the screen share, Ms. Radhika?
I think I can do that. Just let me try.
Okay.
Yes, can you please try now? I think you should be able to.
Okay, just 1 second. Yeah, I will do that. Is my screen visible to the audience?
No, it just says it has started screen sharing, but the screen is yet not visible.
Oh. Maybe I think the connectivity is quite poor in many places. Particularly today, I was attending some few NCLT cases and hearings. We were not able to even listen to the comments of the honorable bench, the members. So thank you very much once again to all the learned audience for this program, panel discussion on case law. As I briefly introduced myself, I am with the IBC practice from 2017. Thanks a lot to this profession. It has given me a lot of experience, knowledge, and understanding in handling multiple cases. Handled so far about 12 to 13 IBC matters, and a few of them successfully. So I am here to share some of my little understanding on this subject. I beg a pardon of the learned members in case anything you find wanting in this. If at all it is there, it is due to paucity of time. Anyway, thank you very much. I proceed now. The case law which we are going to talk about is Telangana State Trade Promotion Corporation versus AP Gems and Jewelry Park Private Limited and Phoenix Tech Power Private Limited. This Phoenix Tech Power Private Limited is the financial creditor. Actually, the case came into being, this order of the company came into IBC based on an application filed by this TS TPCL. You call it as shortly as TS TPCL, Telangana State Trade Promotion Corporation Limited. This stems from the NCLT Chennai. NCLAT Chennai order is dated 21st September 2021. The impugned order is actually 4th January. It is not 4th February. It is actually 4th January 2021. I think there is a small typo on that. So we are going to discuss about the implications of this particular two orders. One is the NCLT Hyderabad order dated 4th January 2021 and the NCLAT Chennai order 21st September 2021. And for a brief understanding, once again, I repeat, in this appeal before the appellate tribunal, the appellant is TSTPCL, Telangana State Trade Promotion Corporation Limited. And even though they are the appellants, here, they got into the COC only in the 7th COC meeting. Until then, they were in the lobby, perhaps I think for being verifying the credentials of the company, the creditor, and thereafter in the 7th COC meeting only they are getting into it. And the applicant financial creditor for bringing in this company into CARP is Phoenix Tech Power Private Limited. I would like to stand corrected if I had said earlier Telangana was the applicant. No, Phoenix Tech Power Private Limited is the applicant financial creditor, and the CD is AP Gems and Jewelry Park Private Limited. These are all the three characters, important characters in this case law. And if I go a little deeper on the important aspects, the CARP commencement was on 4th of June 2019, and from the details what I could gather, there is no assets in the company, no employees in the company, and whatever was there was attached by the Enforcement Directorate. And surprisingly, when the 4th June 2019 order was pronounced by NCLT, Dr. K.V. Srinivas was the IRP. Later on, he became the RP. To his surprise, he found that the name of the company has been struck off from the register of companies. So what I gather is that he had again restored the name of the company by filing an application with the NCLT. And in order to continue with the CRP process, he had to restore the name of the company. And over a period of time, several events in the CARP should have happened. I'm not getting into all those, in between what has happened. Mostly, on account of UOI, RFRP, and then resolution plans and litigations in between. Like as I said, in the 7th COC meeting only, the other creditor is getting into the COC, and there is only one COC until then, and that one COC member, only one COC member, that was Phoenix Tech Power Private Limited, which had 100% voting in the COC. And the issues came when the resolution professional admitted admitted Telangana State Trade Promotion Corporation as a financial creditor and allowed him into the COC. So when this TSTPCL came into the COC, the voting share got greatly disturbed. Until then, this gentleman, that is the Phoenix Tech Power, had 100%. But when this person also was admitted, then the voting share got disturbed. So then there was contention raised by the parties that the Telangana State Trade Promotion Corporation is a related party and cannot be included in the COC. That was the contention of Phoenix Tech Power. And the Phoenix Tech Power Private Limited had the approval and the affirmative confirmation from NCLT Hyderabad that the TSPPCL is not a COC member. He cannot be a COC member because he is a related party. Then the Telangana State Trade Promotion Corporation went on appeal to NCLAT. And there again, this issue of whether it is a related party or not was examined in great detail. Of course, I must say that since this order came in September 2021, the order which was discussed elaborately and nicely by Anagha, I think that order also finds a lot of mention in this Telangana State order of NCLAT. A lot of things have been borrowed from the earlier order of Phoenix ARC matter. So it becomes easy for me, I think, to give a brief idea about this particular case. What are all the key points which have come up in the discussion while deciding whether a particular creditor, a financial creditor, whether he is a related party under section 5 subsection 24. I think that was greatly discussed in deep aspect, in great details. But here, in both the cases of the NCLT as well as the NCLAT orders, the talking points, the key points revolve around 4 items. One is about the management and control being exercised with reference to the corporate debtor. Okay, the Telangana State Trade Promotion Corporation, TSTPCL, in what ways it exercises control over this company, corporate debtor, that is AP Gems and Jewelry Park. What I understand here is that this particular company, AP Gems and Jewelry Park Private Limited, had some sort of shareholding, of which 11% is held by this Telangana State Trade Promotion. TSTPCL holds about 11% of the shares. At the same time, the managing director of the State Trade Promotion Corporation is also a director in the corporate debtor in the AP Gems and Jewelry Park. In addition, one more director also is nominated on the board of the corporate debtor. So what I'm trying to say is that there is some sort of a kind of involvement in the management and control of the corporate debtor by the financial creditor. The financial creditor here is the Telangana State Trade Promotion Corporation. So the question is whether TSTPCL is exercising management and control on the operations, the directions of the company, the corporate debtor, number one. Number two, what is the articles of association of the corporate debtor saying? What kinds of control will be exercised? Who can exercise control? What are all the items of operations where affirmative votes is required from a particular shareholding group? For example, here 11% is held by the TSTPCL. What kind of permission or authority from the directors of TSTPCL is required? in the corporate data while running the organization in terms of decision making, what the articles of association is saying. This is number 2. So number 3, role of nominee directors. What kind of role the nominee directors exercise on the board of a company, of the assisted company, or where there is a funding has been done. I think this subject has been of paramount importance and relevance today, because a lot of banks, financial institutions are appointing their nominees on the boards of the borrowers, the borrowing companies, what kind of role they are exercising. And they are supposed to take care of the interest of the parent, banks or financial institutions. They have a responsibility, they have a role. And more or less, they have to exercise kind of control over the company as similar to an independent director. But here, their role is perhaps limited to the interest of the lending institution. To that extent, we can say that these directors are taking care of the interest of their parent organizations. And the last aspect, I have taken only the key points, not all the relevant issues which have been discussed in the orders. The last one is what kind of a disclosures made by the corporate data in its annual reports. These things have gone into the details. These things have been seen both by the honorable adjudicating authority as well as the appellate authority. And a little bit of additional information I thought I can share with you is that the resolution professional, a learned insolvency professional, took his time to decide whether this Telangana State Trade Promotion Corporation is a financial creditor or not, number 1, whether he is eligible to sit in the COC. So for these aspects, I think he has been preparing, or he has been examining these aspects, like, asking himself a few questions. What kind of role this company is exercising? Is he eligible to be called as a related party? These kind of questions have been raised by him in a few meetings. And thereafter, in the 7th COC meeting, he admits TSTPCL as a financial creditor and also as a member of the COC, stating that he is not a related party. I think even prior to that also, in one of the other meetings, earlier meetings also, there has been some discussion which has happened that resolution professional is, considering the claims submitted by Telangana State Trade Promote Corporation as a financial creditor. And this has also been recorded in some of the minutes. And at no point of time, the other only financial creditor, that is Phoenix Tech Power, did not raise any objection. It looks like, from a reading of the 2 orders, that Phoenix did not raise any objection of, this TSTPCL also being admitted as a financial creditor and also into the COC, but he did not bring them into the COC. He did not, resolution professional did not admit them into the COC, but there was some discussion going on and he has been updating the COC. So these are all the key aspects. And before I get into, the other important observations, what I have made in the order, it would be of interest, for the audience, what kind of, wordings the NCLAT, Honorable NCLAT, has used in respect of this control. Section 2 and, clause 27, the definition section of Companies Act, has been talking about the control. What is the control in respect of a corporate, in respect of a company? So there are various kinds of control which can be exercised. For example, control by means of the composition of the board of directors, or the control can be exercised by, way of decisions taken in the policies of the company, and also in some cases appointment of key managerial personnel, appointment of other directors. Like this, the several kinds of, the control is exercised by way of a shareholding, by way of a presence in the board of directors, by way of subscribers to the memorandum of association. So these are all certain aspects of control which has been exercised, which are normally exercised by companies. And I believe that the word control, which has not been defined in the IBC, so it goes back to the provisions of IBC, where I believe section 3, clause 37, section 3, clause 37 talks about words and expressions used but not defined in the code. So there is a kind of a residuary clause which says that if some of the words which are used here in the code are not defined here, then you go back to some of the the enactments. They are particularly talking about acts like Indian Contract Act, Indian Partnership Act, SECRA, Securities Contracts Regulation Act, SEBI Act, and Recovery of Debts Due to Banks and Financial Institutions, LLP Act, and the Companies Act as well. And while doing this, I think it is very interesting that NCLAT has made a comment that the real test is whether a person controlling either the steering or the accelerator, the gears and the brakes. If the answer is in the affirmative, then he would be in the control of company in the considered opinion of the tribunal. By interpreting the definition of control aspects, if I may go back to this one, the management and control, the NCLAT comes to the decision that two directors, the managing director of TSTPCL coming into the board and another director coming into the board, then there is a certain element of control being exercised on the board of directors of the AP Gems and Jewelry. And another thing, the quorum of the board for certain decisions, important decisions, there is a provision in the constitution documents of the company, the corporate etat, which says apart from the other directors of AP Gems and Jewelry, at least one director should be there in the minimum required 3 directors. So 3 directors are required, voting, positive voting, affirmative voting of 3 directors are required. Certain key decisions in which at least one director has to be from the Telangana State Trade Promotion Corporation. So this is one of the provisions containing in the constitution documents, the shareholders agreement and other documents of the company. So that the NCLAT as well as the NCLT picks up to say that there is a control being exercised on the management of the company. Policy decisions, yes, policy decisions also, this person has to be there. Definitely he has to be there. And the second point, as I was talking about, is the articles of association. The order particularly deals with Article 62. It is talking about Article 62 of the Articles of Association of the company. I think in this article also there has been certain very clear kind of requirements which has been specified, and that goes to say that this particular company has to be under the control, and there is a requirement for the other directors, the directors from TSTPCL, to be there for every important decision. I can just say that from a relevant paragraph, this is the order by NCLT, the first order, impugned order. It talks about it is clearly evident that nominee directors of the company have significant influence in the functioning of the corporate etat, and they cannot now claim that they are only nominee directors and they do not have much role in the corporate etat. Such a claim is untenable. How come this is recorded by the NCLT after examining the provisions of Article 62 of the Articles of Association? They have taken this view, and based on that, the exercise of control being done, the related party definition of section 5 subsection 24, the NCLT clearly says that these people, that is the Telangana State Trade Promotion Corporation, comes under at least 3 or 4 limbs of the definition of related party. If I may add here, if I may show here the provisions of section 524, related party. So the NCLT decision, it says, the Telangana State Trade Promotion Corporation is clearly a related party as defined under clauses A. A is that a director or partner of the corporate debtor or a relative of a director of the corporate debtor. So he is there, so it is a related party. And H, any person on whose advice the screen is visible to the audience. I hope the screen is visible, Adhika.
Yes, sir. Your screen is visible, but it just shows your PPT. If you're trying to show the sections, that is not visible.
Oh, I see. It is showing.
It's showing your PPT only.
Okay, 1 second. Is it showing now the related party definition? Yes. Okay, so this related party definition has been dealt, at great length by Ms. Anagha. So here we talked about A and also H. H is any person on whose advice, directions, or instructions a director, partner, manager of the corporate debtor is accustomed to act. So the NCLT decided that the company, that is AP Gems and Jewelry, acts on the instructions of the directors of Telangana State Trade Promotion Corporation. So they said that it is a related party. Then I think they also talked about J, L, and M. J is what? Any person who controls more than 20% of voting rights in the corporate debtor on account of ownership or a voting arrangement. I think this subsequently fails, because the voting share is 11%, not the threshold of 20%. And okay, L is what? Any person who can control the composition of the board of directors or corresponding governing body of the corporate debtor by virtue of the two directors nominated by the TSTPCL, Telangana State Trade Promotion. They are able to control the composition of the AP Gems Jewelry's board of directors. So this finding also has been made by the NCLT. And the last one is the limb of M, 524M. Actually, 524M talks about four kinds of situations. It talks about any person who is associated with the corporate debtor on account of participation in policy making processes. As we spoke right now, a few minutes before, this particular MD of the company, MD of Telangana State Promotion, is sitting in the board of the AP Gems and Jewelry, and another director. Together they take part in the policy making process. So here also it gets hit as a related party, and having more than two directors in common between. So this was not applicable. Interchange of managerial, not applicable. Provision of essential technical information. I think here there was a contention by Telangana State Promotion Corporation that they don't provide any kind of technical information, but still the participation in policy making process was found to be one of the reasons attributed by the NCLAT to take a decision that this particular company, State Trade Promotion Corporation, is a related party for the AP Gems and Jewelry, and therefore even though they are a financial creditors, they cannot sit in the COC. So that decision has been taken by the Honorable NCLAT. I would like to quickly, show you the order, the relevant terms of the order. Just 1 second. The order. One second. Yes, I got the order now. This is the order. Is it visible, Radhika, on the line, on the screen?
Yes,
Okay.
sir. Yes, sir.
I'm sorry for a little bit of delay. I think my network is having some issues. So this is the order issued by the NCLAT Chennai Appellate Jurisdiction and the Telangana State Trade Promotion Corporation versus AP Gems and Jewelry. And I would like to show you that they have just narrated the NCLT order, the impugned order terms and conditions. And thereafter, they have talked about the background, what kind of, the NCLT start of the process, IBC process. I think it, goes back to the days like the state was bifurcated into AP and Telangana, and the company, how it came into existence. And a lot of transactions which have happened between these two companies, because Telangana State Trade Promotion Corporation provides some land to the company and gets some share for about 11%. The balance amount is taken as loan, and that's how they become the financial creditors. So and thereafter, the other company, that is the Phoenix Tech Power, come into the picture as an applicant financial creditor. They have also lent some money to the company, and there is some outstanding. So these are all the appellant submission. Appellant is that, the Telangana State Promotion Corporation. Here you can say that, the 5%, 5.1 plus 5.9, just 11% with no voting rights. In fact, the appellant holds 11% voting rights, and hence section 24(5)(j) is not applicable. I think this contention has been accepted by the NCLAT because the threshold rate was something like about 20%. And in the other paragraph, it talks about the participation in policy making of the first respondent, nor there is interchange. All these things, has been contested by the appellant, but NCLAT finally comes to the conclusion that, there is a policy making, contribution. Now I will go to the important areas where the NCLAT forms an opinion. It goes through and then puts across the order, the contentions of, both the respondents and the appellants, and vital element and vital element. So when they talk about the vital element, the essential element in regard to the exercise of control is the power to appoint majority directors. So they take that, this is the most important thing which decides whether it is a related party or not. Any para 54, anyone who by exercise of voting power can control the decisions of a general meeting can be said to control the company. A person can be said to be in control of the company when there was no matter or perhaps no substantial matter on which he could be outvoted at a general meeting. So these are all some of the paragraphs where they deal with the control aspects. And then there is an evaluation in para 58. So there they talk about, how these things have happened over a period of time, and the what is the prayer given by the appellant. And they go in depth into the orders of Phoenix ARC. In this connection, the tribunal amply points out the decision of the Honorable Supreme Court in Phoenix ARC Private Limited versus Spade Financial Services. I think about, not less than 10 paragraphs, 10 pages goes on to show that, the Phoenix matter is, very, very relevant here, and which has been, discussed in the previous session by Ms. Anagha. So I just take you now. Yes. It must be borne in mind that the expression control in section 29AC of IBC symbolizes only the positive control, that the mere power to block special resolutions of a company cannot amount to control. In reality, the word control juxtaposed with the term management means de facto control of actual management or policy decisions that may be or in reality taken. So here, this tribunal points out that the appellant's managing director was also a director of the first respondent, that is AP Gems and Jewelry. Moreover, the director nominated by the appellant, in fact, advises the appellant company in matters relating to the company. So, to put it precisely, the part played by the two nominee directors clearly point out that the first respondent company acts on the advice, direction, and instructions. So, this is what they are saying. And one more thing, you can see paragraph 68. The other important fact that cannot be brushed aside is that the first respondent, that is AP Gems and Jewelries, had reported the transactions between the appellant, that is Telangana State Trade Promotion, and the company CD in their annual reports and audited financial statements, that they are a related party. You may remember that in the annual reports, annual accounts of the company, by virtue of the notes on accounts as well as the accounting standards, you have to disclose the related parties and also the transactions, the element of transactions and what nature of transactions. Those things have to be shown. And whereas AP Gems and Jewelry has listed some of the transactions with them, with this company and Telangana State, and they have by themselves admitted that it is a related party. So that has come, handy to the appellate tribunal as well to decide that they are the related party. And you perhaps may remember that in one of the clauses they had mentioned about the control aspects, that somebody is in control of the steering, the brakes, and then the accelerator. Then it is definitely decided that it is in para 57 they talked about this control aspect. Yeah. 56, if you take 56, in this connection, Tribunal Worth recalls and recollects the decision in Inland Revenue Commissioners versus Bibi and Sons Limited, wherein it is observed that the term controlling interest does not refer to the director's beneficial interest in the company, but to the power of controlling by votes in the decision binding the company in the shape of resolutions passed at a general meeting. 57 para. The real test is whether a person controls either the steering or the accelerators, gears, and brakes. If the answer is in the affirmative, then he would be in the control of company in the considered opinion of this tribunal. So ultimately, the final conclusion arrived by the appellate tribunal goes on to say that the decision of the adjudicating authority is absolutely perfect, doesn't require any kind of interference. I think it comes into, yes. If I read paragraph 70, it is to be pointed out that the articles of association point out that action relating to significant matters ought to be taken only by affirmative vote of 3 or more directors, and in the qualified majority, minimum 1 director is to be nominated for inclusion by APTCL. It is actually TSTPCL. Be that as it may, in the light of the detailed upshot and considering the facts and circumstances of the instant case in a conspicuous fashion, and keeping in mind the ingredients of articles of association to the effect that the nominee directors have a vital influence in regard to the working of the corporator, this tribunal unhesitatingly comes to a consequent conclusion that the appellant is a related party, and the view arrived at by the resolution professional to include this company as a member of Committee of Creditors is clearly unsustainable in the eye of law. And in this regard, this tribunal concurs with the view arrived at by the adjudicating authority in the impugned order. And therefore, the resolution professional shall reconstitute the Committee of Creditors, treating the appellant as related party is free from legal errors. So instant appeal fails. In file, the company appeal is dismissed. So this is the kind of the thing. Now, if I may ask the participants, so this has happened sometime in September 21. What happened after this? Was there any conclusion? Did they go to Supreme Court? The matter reached any higher forum, or it got settled there? So I did a little bit of a small research on that. You would be surprised that after this decision of NCLAT, there was only one COC member, which is the Phoenix Tech Power 100%, and the committee went on to get resolution plans, and one of the resolution plans was approved by the committee by the single member. And how much the parties got out of the resolution plan? Any idea? Well, whether the appeal by Telangana State Promotion Corporation succeeded or failed, it has failed finally. But both the parties, that is the Phoenix guy as well as the Telangana State Trade Promotion Corporation, both of them got identical amounts in the resolution plan. I will just share the screen to show that particular order. When that order has been passed, that also I will share. I think this has been passed recently. I think it has been passed on 2nd January 2022. One second. Share screen.
Sir, here may I point out two things?
Yeah.
If you may kindly permit.
Please.
So one is that Telangana State Corporation is a government organization. Number two, whenever the banks, financial institutions, or these, typically the government organizations, they give funding to any company or corporate, these kind of conditions are very, very, they are stipulated, are very normal in terms of, loan giving, and, they have to monitor how the loan funding is utilized by the corporates. So can you still think that this is truly a related party relationship, given that factor?
One thing I would like to say, there is an exemption carved out in section 21, and that is for only defined financial service providers. If I may read that, the second proviso to section 21, that a related party cannot be in the COC. There is a proviso, separate proviso. This particular provision shall not apply to a financial creditor regulated by a financial sector regulator. Now, if I may ask you whether this trade promotion corporation is regulated by the RBI, so that question fails.
Okay. No, it is not.
So that is why they said that, when you are saying that it is a government sector, government company, government corporation, there was no other motive. So, how you can treat them as a related party. So that argument did not, go through well in the both the courts, adjudicating authority as well as appellate authority. And this is the order. You can see the order is dated 3rd January 2022. And, 3rd January 22, the resolution plan submitted by a company called ACE Urban Developers Private Limited, resolution applicant, has been approved by the Committee of Creditors as well as by the Honorable NCLT. And that is a successful ending for this particular case. And I just wanted to show you, how the entire process has gone, and what is the amount allocated. This is a 100% voting share, Phoenix Tech Power Private Limited. 107.10 crores. The amount looks to be substantial, 107.1 crores as the resolution plan amount. But if you really go into the details, they give only about 25 crores. You can see here amount provided under the plan, 8.33 crores for Phoenix Tech Power, and exactly double the amount, 16.66 crores for Telangana State Promotion. But in terms of the percentage on the amount claimed, it is both standing at 43.33%. Okay, then what is that 107 crores and this 25 crores? 80 crores they have mentioned as infusion into the company towards working capital. So you can see here, the kind of amount spent on CRP expenses also because of the litigation and other things, I guess 2 crores CRP cost. Operational creditors 5 lakhs. this is the amount provided in the resolution plan. And financial creditor 1 is TSTPC 16.66 crores, and Phoenix, the guy who started originally the application under section 7, he gets 8.33. Now a question comes, by way of fighting it out in the NCLT, in the NCLAT, and having become 100% voting shareholder in the COC, whether Phoenix could achieve something, I don't know actually, because in terms of the size of the amount outstanding, 2/3 would be controlled by Telangana and 1/3 would be controlled by Phoenix. So a resolution coming up for voting, Telangana might block it, might stop it. Whereas Phoenix, now being 100% voting shareholder, has been able to approve it and then clear it. And now it has been, finally it has seen the end of the tunnel. And that's how the resolution plan approval finally has been stamped and issued by the Honorable NCLT. I think somewhere they have also talked about the journey where the parties have gone on appeal on the the decision of whether Telangana state is a related party or not. All those things are forming part of this order. So interested participants, definitely you would like to go through this order in detail. It is available in the IBBA portal. Definitely it makes some interesting reading. I think now it is time is 5:50, Radhika. I would like to conclude my presentation on this thing. One small this thing. Yeah, related party transactions. 1 minute. Am I sharing the screen now? It's not there, no?
Yes, sir. It's not visible right now.
Okay. So I have talked about this management control, articles of association, role of nominee directors, disclosures in the annual report. And the control aspect also we have seen. NCLAT, finally, it says that TSTPCL is a related party and cannot be a member of the COC, upholding the order of NCLT Hyderabad. Resolution professional directed to reconstitute the COC accordingly. An update on this is on 3/1/22. Plan submitted by AS Urban Developers Private Limited has been approved by the loan member Phoenix and also approved by NCLT Hyderabad, 27.10 crores. And the payment terms is just 90 days and 43.33% is the amount going to both the financial creditors claims. So thank you very much, the audience for being with me, and thank you very much. And I think a few questions can be accommodated, Ms. Anagha and Radhika.
Yes, sir. I would request all the participants to please ask whatever queries they have from sir and ma'am.
Radhika, I'll be sharing my presentation as in I have a note which is prepared in, because a lot of material is there from the case law. So I did not want to show it on the screen because it's too verbose. I'll be circulating that after the session, and you can please circulate it to all the participants.
Sure, ma'am. Sure, ma'am. Thank you so much.
I think there was one gentleman who asked a question that at the time of giving a loans and other covenants would have been there. May I request the gentleman to kindly revisit? You still had clarity on this, or you have some more?
I got a clarity, sir. I got a clarity. But normally, that was only one clause. Is there any other clause in which, like there is an exemption carved out for the financial creditors like these to be, sort of be separated from the, corporate debtor actually?
Yeah. I'm Mr. Anil, I think it's a good point. We have to be really careful at the time of lending, because nobody knows at what time the company will go into IBC. The people who have been very comfortable with shareholding in companies are all now feeling that their shareholding is worth nothing if the company goes into IBC. The shareholders are absolutely left in the lurch. They don't have any kind of rights in the IBC process. As you all know, that Section 53 puts them at the bottommost, area in the waterfall. So, these are all some of the things which are emerging. And I don't know, you made it a very good thing at the time of issuing a loan or, covenants in the loan agreements. How the lender has to protect themselves is very, very important.
Thank you, sir. In fact, we have seen in case of DHFL and
Yes.
few other cases, that shareholders have lost practically all their money,
Correct, sir. Correct. Absolutely. And in the multiple banking arrangements, I know of a recent case where there were different lenders to a company, and many of the accounts were under default NPA, but there was one account which was going good, and one of the nationalized banks had given the loans to the company, and it was very sound, and revenues were generated month after month, and it was in standard, account was standard, but the company got into IBC. Then what else they can do now? Everybody has come into the pool now, COC, and the bank which is getting serviced every month regularly, now it is not getting the money because it is going to the RP now. And there is a moratorium. No amount can be paid to the lenders during the moratorium. So these are all situations where, a lender has to think, quite a bit of exercise before giving monies to companies which may potentially become an IBC company.
But sir, then there should be an amendment to this extent in the IBC, whereby, there's ample protection for the lenders who are not related in the true sense, or they are independent, they are purely lending, so they do not fall under the trap of this related party matters,
Correct.
Of course, when there is a relationship established, there is a relationship. But, in case of pure commercial transactions, this can be a problem.
Correct, sir. Correct.
Thank
Maybe
you,
we
sir.
can use this forum to suggest these amendments, when we are having these discussions. We can use this forum, and through the IPA, maybe we can suggest what all the things we need to, because we as RPs, we are dealing with these things on a day-to-day basis. Now, what is written in the law, like the law, we generally understand that the related parties have to be seen as on the date of CIRP, or, at least at the time of resolution plan, all those things, depending on the context. But if we go to the Phoenix ARC case, also they have gone so much back in time.
Correct.
And they have seen that at that point in time, then what was the intent behind entering into those transactions? As RPs, we have to implement those things.
Correct.
And we have to be on our toes when we look at these transactions. So it is in the fitness of things that we ourselves suggest these amendments. So maybe some of them might get actually translated into the code and makes our life simpler.
Absolutely right.
Agree with you, ma'am. Agree with you. But, normally what happens is, like in Phoenix ARC, it was, I think, actually appropriate to go backwards to really establish the relationship, because it was, party to party. But here, when, these lenders in the true sense, like banks, financial institutions, or, government organizations are involved, then, or even, otherwise, like ARCs are there, AIFs are there. In that case, their main business is to lend, so they should be separated actually from.
Yes, I mean, that exception should be carved out in the code, in the definition when we're talking about related parties. And what I was suggesting was we should suggest these changes, and maybe through the IPA, then they can forward it to the IBBI for consideration whether such an amendment can actually come in the code. So it will help everybody.
Correct.
True.
Sir, Mr. Paramasivam, you have any comments or suggestion?
Appreciation to you. It's a good program. We are enjoying.
Thank you, sir. Thank you. Thank you.
Thanks to you, and also, madam.
A pleasure.
Thank you.
So if there are no further questions, then I would like to thank the IPA and Mr. Rajendran sir also for this opportunity. It was good interacting with you, sir.
Thank you very much.
The participants.
It's a great, again, pleasure working with you and hearing you, listening to you today. Unfortunately, there has been a hectic time the last 1 or 2 weeks. I couldn't be in touch with you. Thanks. Thank you so much.
Thank you.
Yes.
Good evening, everyone. On the behalf of ICSI IIP, I would like to thank ma'am and sir for delivering such an enlightening and intuitive session today. Thank you so much, sir and ma'am, for being a part and taking out time for this session. Thanks a lot on the behalf of ICSI and all the participants.
Thank you.
Thank you. Thank
Thank
you.
you so
Our
much.
pleasure.
ma'am.
Thanks for having us.
Thank you, sir. Thank you so much.
Participants.
Thank you. Thank you so much.
All the very best to you, sir. Thank you.
Thank you.
Thank you, sir. Thank you
Thank
so
you,
much.
ma'am.
Thank you very much. Thank you.
Register number any page register number page ਤੇ ਨਾਲ ਭਰ ਦੇ उनका यार 19 ਦਾ ਭੇਜਣਾ ਸੀ ਕੋਈ ਰਹਿ ਗਿਆ